Hi, Con Law class. This is Professor Opterbeck, and I'm catching up on my summary and review videos for you. So we're going to go all the way back to week 7. And in week 7, we were talking, continuing our discussion of executive power. And we also began our discussion of the post-Civil War amendments. So the first thing we were talking about in week 7 were these questions about bicameralism and presentment. So what is necessary for Congress to enact a statute, and how does it have to be presented to the President? So we saw in Article 1, Section 1, that the bicameralism requirement, which is that the legislative powers are invested in a Senate and a House. And we saw in Article 1, Section 7, the presentment requirement, which requires that once the House and the Senate agree that the bill is presented to the President may then sign it or veto it and send it back. So how do those things work out in some of the case law that we looked at? One of the things we looked at was the extent to which Congress can delegate any of its powers to the executive branch. And as we kind of discussed in the modern administrative state, it is necessary to have some degree of delegation, at least, because the agencies that are administering many of the regimes that Congress comes up with are really going to be located in the executive branch. So basically, as we looked at it, we see that there's a very, very minimal standard, which is the intelligible principle standard. So long as a congressional delegation of some authority to the executive has some intelligible principle through which the executive makes determinations, then that delegation generally is going to be acceptable. We also looked at a couple of other questions, the legislative veto and the line item veto. So if you recall, the legislative veto is the idea that within a statute there is an opportunity for the legislature to go back and veto or override some decision of the executive. And we looked at that in the context of INS v. Chadha, a case with an immigration provision, and we saw that the Supreme Court rejected the idea of a legislative veto, and we talked a bit about some of the policy and lawmaking implications of that. We also talked about the line item veto, and if you remember, the line item veto was a statute where the legislation would allow, where the executive would be allowed to strike out individual lines of a piece of legislation that had been presented before signing it, rather than vetoing the whole legislation and sending the whole thing back. And as we discussed, the Supreme Court rejected the line item veto as not provided for by the presentment clause in the U.S. Constitution. As we mentioned, there are many states, like New Jersey, that have line item veto provisions, often for specific things like tax bills or spending bills and so on. But in the federal context, it's not in the Constitution, and the Supreme Court has said that there is no line item veto. We talked then a bit about the appointment and removal power. And so Article 2, Section 2, Clause 2 vests the appointment and removal power in the executive. And so recall that the President nominates, and with the advice and consent of the Senate, appoints ambassadors, public ministers, counsels, judges of the Supreme Court, and other officers. And the question we looked at there was some possibility for Congress to remove officers that had been appointed by the executive. And we saw in that case that the Congress cannot retain that removal power. That the court has said that once the executive makes the appointment, that is the executive's choice, and it is up to the executive to decide whether or not that officer is to be removed. And if Congress does have a remedy, it is in rewriting a law that might have created some executive branch office that would appoint this executive officer, to the extent that would be possible given the kind of officer that it might be. We talked then about how all of this plays into the idea of the independent counsel or the special counsel. And of course, the special counsel, Robert Mueller, has been quite a bit in the news over the past year. So with respect to the independent counsel, we saw that there was a statute which allowed the Attorney General, having done an investigation and deciding that there might be a conflict of interest, to appoint, to go through a procedure that would result in the appointment of a special counsel. And the question is whether that statute violates the Appointments Clause, and the court said no, that the independent counsel is actually an inferior officer, is not the kind of officer that the Appointments Clause is kind of suggesting falls into that exclusive domain, and so is not the kind of officer that can only be appointed directly by the president. Second issue there was whether the Attorney General's ability to remove that officer for good cause interferes with the president's power or violates separation of powers. And again, the court said, no, it does not. The executive still ultimately retains a removal power, and there's not an impermissible undermining of the executive. Now, as we talked about this, we mentioned that that particular statute that was addressed in Bowsher v. Sinar had since expired by its own terms and had been replaced by the independent counsel statute. And so we talked a bit about the provisions of the independent counsel statute, how an independent counsel gets appointed, on what grounds an independent counsel could be disciplined or removed, and how those things kind of relate to the current events that are in the news. And with all of this, as we discussed, this creates a kind of potential separation of powers tension with the executive branch and the role of the judiciary and the independence within the executive branch of the Attorney General, and those debates kind of continue. We talked also about executive privileges and immunities, and we talked about the executive's liability to civil suits, and we talked about the impeachment power. So with respect to privileges, executive privileges and immunities, we talked about the Watergate era, the Nixon tapes, the Watergate tapes, and the fact that the Supreme Court did, on balance, after applying a balancing test, find that the executive can assert a privilege against the release of certain information in relation to the administration of justice. So this is really creating or recognizing a new kind of privilege. And once the executive invokes that privilege, then the court has to look at it and determine whether the material really ought to be released because it's essential to the administration of justice. So kind of a balancing test, but the executive can invoke that privilege. We talked about the president's liability for civil damages, and we noted that the president is immune from civil liability for official acts unless Congress says otherwise. So in the exercise of the president's office, in the exercise of the president's official duties, the president cannot be liable. So the president makes a decision that costs somebody money or something like that, the president can't be liable in a civil suit. But we also talked about unofficial acts. And there we talked about the Clinton v. Jones case, and Paula Jones claiming that she had been sexually assaulted by President Clinton when he was governor in Arkansas, and whether that suit could proceed against the sitting president. And we saw that the majority of the court said that yes, indeed, that the president can remain liable for those ordinary civil harms outside the exercise of the presidential office. It doesn't create any separation of powers issues. It may create issues in terms of the administration of the case and how fast discovery can proceed and so on. Although, as we saw in the Clinton v. Jones case, that discovery did proceed. It doesn't immunize a president from discovery. And then we finally talked about the impeachment power. We saw that the standard for impeachment in the Constitution is relatively vague and perhaps intentionally so. We talked about the impeachment of President Clinton in the Monica Lewinsky scandal, and we talked about the debates at the time over whether that rose to the high crimes and misdemeanors level or not. And we at least have a historical precedent. It's not a binding legal precedent, but a historical precedent that, in fact, the president was impeached for those activities. But we also talked about how this is very much kind of a partisan question. So that's the first half of the review for week 7. I'm going to close off this video, and then I'll do a new video for the second half of week 7, which begins to talk about the 14th Amendment and incorporation.